Welcome back to Legal Base. In this video, we will be covering some important questions related to Indian Evidence Act which can be put upon in an interview. So without wasting much time, let's see the questions. So the first question is, what is an evidence given for? The evidence is given for facts. The facts can either be fact and issue or relevant fact. In coming up questions, we will be discussing in detail fact and issue and relevant fact. The next question is, how are the evidence for facts given? In what manner the evidence is given? The evidence can either be given orally or documentary. When some proper documents are given, it becomes documentary evidence, and when it is orally spoken, then it becomes oral evidence. So the next question is, on whom does Indian Evidence Act does not apply to? So the answer for this question is the court martial which is convened under the Army Act, under the Navy Discipline Act, Indian Navy Discipline Act and the Air Force Act. And apart from these, affidavits that are present to any court or officers and the proceedings done before an arbitrator excludes the applicability of Indian Evidence Act. So the next question is, on whom does burden of proof lies? So before going into this topic, we need to understand what is burden of proof. Burden of proof is the obligation to prove a certain fact. In normal cases, generally, burden of proof lies on the plaintiff. Who is plaintiff? Plaintiff is the party who is introducing the suit. But in certain circumstances, burden of proof lies on defendant as well. For example, a rape case. So the next question is difference between admission and estoppel. Admission is a written or a oral statement which defines the rights and liabilities of the party, whereas estoppel is a rule of evidence which prohibits a person from giving a false evidence. That is estoppel. The next question is hearsay evidence. Hearsay evidence, we can say that it means suni sunai baat, the thing which is not personally communicated but heard is known as hearsay evidence. So the next question is doctrine of res gestae. That means that when the facts are forming the part of the same transaction automatically, when same transaction is being formed by the facts proved, then the doctrine of res gestae is applied. The next question is plea of alibi. Plea of alibi means the plea taken that I was not present at the crime spot at the time when the crime was being performed. So the plea that I was somewhere else, that plea is known as plea of alibi. The next question is, why it is seen that there are so many cases where hearsay evidence is excluded. What is the reason behind exclusion of hearsay evidence? The reason is, as if hearsay evidence is not excluded, it may encourage the substitution of weaker proof for a stronger proof. So to do not give importance to weaker proof, hearsay evidence is excluded in many cases. The last question for this video is very important as it is related to relevant fact and fact in issue. So what is relevant fact? Relevant facts are those facts which is legally admissible as an evidence, and fact in issue are those facts which is yet to be proven. These facts does not have any existence, it is yet to define, like their nature is not defined, it is yet to define. So these facts are an issue. That's it for this video. Thank you. All the important questions related to Indian Evidence Act was covered herein. If you have any queries, then please let me know in the comment section below. Thank you.